What's going on?
Yeah, exactly.
Doing any traveling recently?
Going to Utah tomorrow morning.
Utah?
I think so.
Vacation or?
No. All right, welcome back. Ready? Guys, ready? Okay, very good. I finished grading your midterms. You'll probably get it back, I think, tomorrow. So the way it'll work is you'll go to Terry May's office. It's on the 8th floor. I'll send you the room number and pick them up. What time does your first class start tomorrow? So I think she stays till 5:30. So I don't want to make her stay late. So if you get there by 5:30, it would be very nice for her, so she can give you back your papers, if it's possible. If not, you'll pick it up on Wednesday 5:30 or Thursday 5:30. But I think she only stays till 5:30, and I don't want to make her stay late. So I think that'll be the deal. Okay. Okay. Any questions on what we covered last class, where we finished up the equal protection component with gender discrimination, Cleburne, heightened scrutiny? Any questions? Okay. We are kind of done with equal protection. Not really, because we'll come back to it again, because as you'll see in this class, a lot of the topics overlap. And especially with the gay rights cases, equal protection and due process sort of intertwine among one another. So it's very hard to actually disentangle them. As this book goes from edition to edition, the titles of the chapters start making a little bit less sense, but we'll do our best. All right. But at least for today, we're moving back to the due process clause. We spent a lot of time on due process. We started with cases like Lochner, which discussed whether there's a liberty interest in contracting, right? Choosing how many hours a week you work. We discussed whether there's a liberty interest in minimum wage laws. Those are sort of economic cases. And then we did other kinds of cases. For example, in Meyer v. Nebraska and Pierce v. Society of Sisters, we had restrictions on education and how schools can teach certain languages and whether you can have private schools. And then we had a case like Buck v. Bell, which involved whether a state can forcibly sterilize a person to promote interest in eugenics. So we have all these cases in the 1910s and 1920s and 1930s where the court had a fairly broad view of the due process clause, and they felt compelled to declare unconstitutional laws they deemed unreasonable. But then we took a fork. We get to the New Deal. And that fork started with our favorite case, Caroline Products. We keep coming back to it. It's a very important case. And that case held that generally, if the court is dealing with a right that's not written in the Bill of Rights, then you give it what might be called a presumption of constitutionality, where the court presumes that such laws are valid, unless the plaintiff can come forward and provide evidence to show that the law is irrational. That was the approach we saw with Justice Harlan's Lochner dissent, right? That you have this presumption of constitutionality, but you give enough evidence, you can rebut it. But then we get to the 1950s with the Warren Court, and we have the case of Williamson v. Lee Optical. We keep coming back to that case also, a very important case. And Lee Optical basically said, no. This presumption of constitutionality cannot be rebutted. No amount of evidence will suffice. So long as the government has a conceivable basis on which they've ruled, that's enough. And that's where it leaves us with Lee Optical, 1954, 55, might be off in the year, but mid-50s. Oh, by the way, I'm okay starting class on Wednesday at 6. If anyone has an objection, please email me by tonight. If not, I'll reserve the room. But just if anyone has objections, email me. If one person objects, that's it. But I'm okay starting at 6 and going from 6 till 8. You guys get here a little bit earlier than normal. Okay? Thank you. If you have objections, okay. But if one person objects, I won't do it. That's the way it works. All right. Yeah.
I don't object. I have a question about that.
Thank you.
Maryland case, even though you could rebut, the likelihood is that you still wouldn't.
It's tough.
It's really tough, right?
But it's possible. It's still feasible. There's a possibility you can. But it's an important distinction because there were cases in this era where the presumption was rebutted. But it's hard. But after Leoptical, the court basically said when you're dealing with these rights not in the Bill of Rights, you can't rebut this presumption. Now, there were still during this time that if you have laws affecting the political process, perhaps, or laws that detriment discrete and the interests of minorities, that the court would still give a little bit more of heightened scrutiny. But when we're talking about the due process clause, liberty interests, you basically were done before you started, right? If you raise a liberty interest, you're going to lose. That's the world we live in the 1950s. But starting in the 1960s, things start going in a different direction. And it's not where you think. There's a little reading at the beginning of your chapter on the Fourth Amendment. I signed that, right? And, you know, Josh, why are we learning criminal procedure in ConLaw? Because the court really started experimenting with protecting liberty interests in the criminal realm. This entire notion of a right to privacy, which today we associate with maybe the internet or maybe with abortion, really came about in actual privacy from the government searching your stuff, right? That's where this terminology really got some traction in the 50s and 60s. But still, the Fourth Amendment is in the Bill of Rights. And that's perfectly fine within the Caroline Products framework, right? You have something in the Bill of Rights, give it some heightened scrutiny, that the courts can second guess the police, for example, if they conduct a search, right? But all of that changes when we get to Griswold, right? Griswold is a very important case, not so much for what it says, right? We'll discuss the opinion in a few minutes, but it represents a shift on the court with respect to how they recognize certain types of liberty. And the manner in which Justice Douglas writes his majority opinion, which, again, confuses law students every year without fail. If you were confused, you're not alone. I'm with you, my friends. But the reason why he wrote it that way is important. And to get this, I want to give you guys a poll question to start our discussion for today. And this is your question, right? I'll make it a little bit bigger. It's hard to read. Griswold versus Connecticut was consistent with footnote 4 of Caroline Products. And when you think about this question, Justice Douglas's opinion starts making a little bit more sense. Not a lot more sense, right? I still get confused when I read it. But it makes a little bit more sense. Okay, another. Whoa, people are taking their time with this one. All right. All right, who's next?
I'm next, but I don't have an answer yet on this question.
Okay, well, talk out loud, right? Walk me through what you're thinking.
Well, I was trying to remember footnote 4.1, and
Good.
I know that my note on it says it's an interpretation on when the presumption of constitutionality should be used with caution and used differently.
Okay.
And in this case, give me a second. Well, maybe no, because to this, maybe false, because the holding was that the right of privacy isn't expressly included in the First Amendment, but its existence is necessary in making express guarantees fully meaningful. And that doesn't, I know that holds true to the fact that this is a topic that should be used with, like caution or whatever. But this was not necessarily constitutional because it wasn't something already in the Constitution, if that makes sense. Like
Okay. But can I ask you a follow-up question? Maybe help you out a little bit? Okay.
Because I'm struggling.
No, that's okay. No, I think you said a lot of things that are very good. So let me try and guide you a little bit, right?
Okay.
So we have Caroline products, right? The case involved filled milk, pretty boring, right? Can the federal government ban, condensed milk in a can? Mm-hmm. But the court had this footnote, and there were these 3 paragraphs in the footnote. And I want you to recall these 3 paragraphs, right? And I'll do them in reverse order if I'm getting my memory correctly, right? One of the paragraphs said is, well, if there's some law that impacts so-called discrete and insular minorities, the court's going to have heightened review, right? Why? Because these are people who can't necessarily change the political process.
Insular minorities.
Because they're insulated, exactly, right? So that was one of the paragraphs. There's a second paragraph that said, if you have some sort of law that changes the political process, that is, how people are put into office, right? Courts are skeptical there, because if you jerry-rig the political process, then undesirable legislation won't be repealed in the normal course. Right? So far, so good. This law, as best we can tell in Griswold, doesn't affect the political process. It's a contraceptive ban. And it doesn't really target any minorities. It applies across the board. But then there's that first paragraph of footnote 4, the first part. It says, well, if you have specific guarantees, such as free speech, searches and seizures. He doesn't include the Second Amendment, by the way. Justice Douglas does not mention the right to bear arms. He goes through all of them except for the Second Amendment. But you have these specific guarantees in the Bill of Rights. Courts can still rebut the presumption of constitutionality. Right? And the implication there is if something's not in the Bill of Rights, that is the Due Process Clause of the 14th Amendment, unenumerated liberty, it doesn't get that protection. Right? The entire structure of footnote 4 was to say no more Lochner. No more reading to the liberty provision of the 14th Amendment, all these rights of contract and property and all this other good stuff. So footnote 4 said we're going to limit ourselves to rights in the Bill of Rights. So Monique, let me come back to you, right?
Uh-huh.
Is then Griswold consistent with Caroline Products footnote 4?
If you're limiting specifically to things that are in the Bill of Rights,
More question, I'll let you go after this one, right? Is Justice Douglas's majority opinion limiting it, a right of privacy, to the Bill of Rights?
well, I mean, yes, but it's his justification is using the Penumbra.
Ah, there it is.
It's not like if you were looking at
Good.
it black and white, no.
Good. Yeah. Okay. So this is the way we have to understand Griswold, right? We'll get to the facts in a minute. But you have to understand this at a broad level. These were almost all justices appointed either during the New Deal or in the years following the New Deal, right? They came of age in a time where Lochner and this entire era was evil, right? And if you were trained of saying we can't have the Due Process Clause as the basis for these sort of unenumerated rights, then you can't say that there's a right of contraception or a right of privacy in the 14th Amendment. You can't say that. And Justice Douglas struggles mightily with coming up with something that's not the 14th Amendment. He really struggles. He twists and he turns, he spins around and goes for a tour around the solar system, right? He goes everywhere, right? But then we get to Roe. And at that point, it's like, oh, whatever, we don't care anymore. Fine, 14th Amendment. Look at Justice Stewart, right, in Roe. It's like, okay, I guess we're doing this, right? We're doing substantive due process. The jig is up. But what happens then between Griswold, which is what, 60, 65, and Roe, which was 73, so 8 or 9 years between these two cases, right? There was a shift in how the Supreme Court approaches constitutional law. That the sort of settlement that formed with Caroline Products and Lee Optical crumbled. And the court said, okay, we're going to do it anyway. Let's just stop the pretense. But they do it in a specific fashion, right? The Roe court says we are not doing Lochner. And Justice Douglas says we're not doing Lochner. Right? In fact, Justice Blackmun even says, we're Holmes, right? We're Holmes. He cites Holmes. Give me a break, right? We're Holmes. Give me a break. No way. But the reason why they do this is to say we're not going back to the 1920s and 30s. We're not doing that. So they begin to draw this divide, which I referenced when we did this topic a month ago, between personal liberty, contraception, abortion, etc., and economic liberty, contract, property, etc. And this is how the court, to this day, I think, until Justice Kennedy retired, but this is how the court generally approaches this. So-called economic rights are still associated with Lochner in those evil cases in the 1920s, Atkins, etc. In contrast, personal liberty cases, right, like Griswold, Roe, we'll do Lawrence v. Texas sodomy, right? These sorts of cases are deemed different. And the court eventually gets around to this idea that certain rights are fundamental. And if a right is deemed by the court to be fundamental, then notwithstanding footnote 4, it gets heightened scrutiny, right? It still gets heightened scrutiny. It's unenumerated, not written down, but it still gets extrajudicial review. Now, what makes a right fundamental versus non-fundamental? Judges, right? So Justice Harlan in Griswold gives you one approach to this. Whether something's implicit in the concept of ordered liberty, whatever the heck that means, I still don't know what that means. Teaching this case for years. But the court starts doing all these various tests to keep Lochner away, keep footnote 4 in place, but provide judicial protection of rights that were important during the 60s and 70s, which was sexual autonomy and the like, contraceptive, etc. So you have to read Griswold against that backdrop. That's why Justice Douglas does what he does. So I actually think, and I think Randy and I agree on this point for the large part, that Griswold was an effort to stay consistent, I think it's true actually, with footnote 4 of Caroline Products. But he does so, I think Monique will put it in a fair way, with the Penumbras, right? With this very strange approach. But what he's trying to say is, well, the Bill of Rights is a little bit broader than the Bill of Rights, right? We're still in the Bill of Rights. We're still in that first paragraph of Caroline Products, footnote 4. Still there. But by the time you get to Roe, it's like, screw it. We don't care anymore, right? We don't have to keep up this song and dance. All right, so that general frame makes sense, everybody? It makes sense?
No, we were kind of debating over that. Now, so to be clear, the effort in Griswold by Douglas was a stretch.
Yeah.
But his attempt was to be consistent with footnote. That's why he was trying to
Yes.
align them with
He was trying.
Bill of Rights, trying to make sense of it.
Yeah, exactly. He was trying to make things fit, and you can judge for yourself whether he did it successfully or not. But keep in mind, Douglas wrote Leoptical, right? Not even a decade earlier, Justice Douglas wrote Leoptical, where he said, we are no longer in the business of using the 14th Amendment to scrutinize the wisdom of legislation. So he has to contend with that. And very often a justice won't say, well, I was wrong a decade ago. They'll say, well, I'm right now and I'm right then. And they sort of find a path to reconcile their decisions a decade apart. Yeah, Clay.
So you're saying that they tried to be consistent with the footnote, but it ultimately it wasn't.
By the time you get to Roe, they dropped the pretense, right? At least in Griswold, he tried to keep up the show. But after you get to Griswold, Roe, and there are a couple of cases in the 70s I don't assign, but they sort of chip away at that in the 70s as well. For example, I'll give you an example, right? The crux of Griswold is about married couples having access to contraception. And they make a very big fuss about the marital bedroom, about marriage, right? They keep saying this over and over again. And in fact, the lawyer for Planned Parenthood said, oh, Your Honor, this is just about marriage, right? Just about married couples. Give me a break, right? And a couple years later said, never mind. it violates equal protection to give contraceptive to married couples but not unmarried couples. So, like, the frame they made here was only meant to last for a very short time. Yeah, there's another case, Eisenstadt versus Baird, which was 1970 or so. Might be off by a year or two.
In the Griswold case, that holding in the Griswold case only applies to married couples.
That's all it says.
Doesn't apply to non-married couples.
If you read it carefully, it's exactly what it says.
Okay.
Was that surprising to you when you read that?
Well, yeah, I mean, I was like, maybe that's the part that's not in the book. I mean,
No, that's
I
it.
don't know if you-
Griswold, very good. So Janice's question, Griswold was limited to married couples. That's all it said. And they make a very big fuss about marital bedroom, all this stuff, the institution of marriage, the sacred institutions, all this jazz, right? A couple years later, a case was Eisenstadt versus Baird, B-A-I-R-D. The court said, well, never mind. It violates equal protection to give contraceptive to married couples, but not unmarried women. And so that
Say what not?
it violates equal protection to give it to married women, but not unmarried women.
But not unmarried women.
And that facade, and then that was it. So this entire business fell apart real quick.
Okay.
And one of the ironies, or I don't know if irony is the right word, but Justice Douglas, who's waxing poetic about marriage, was married like 4 or 5 times himself. He left each successive wife for a younger secretary. Like his wives were always in their 20s or 30s. As he got older, his wives got younger. He was a ladies' man in the worst sort. And he wanted to run for president, and he couldn't because he was divorced so many times. That actually killed his Supreme Court. He wanted to run for president. I can't even describe Justice Douglas. He was a bizarre guy. He stayed in the court so long. He actually had, was it a stroke or I think he had a stroke.
It wasn't a stroke.
No, he had a stroke eventually, and he couldn't do his job. So what his colleague said, if he was ever the 5th vote in a case, they'd re-argue it because they wouldn't let him cast the 5th vote. They basically just like walled him off, and then finally he resigned. I saw hands. No more hands?
Yeah, I do.
Kyle?
So I just wanted to kind of clarify what she was going on, right? So my understanding of Griswold is they're like, yeah, the state can legislate against basically extramarital sex, and they can legislate against homosexuality. And
They said that. They said that. Yep.
But the marriage is so sanctimonious that they don't have a right to go and invade that privacy.
Yep.
And then you're saying later they
That didn't really matter.
It's not fair to
Yep.
give them that special privacy, which is what the basis of Griswold was speaking about.
Right. What I'm telling you is the basis of Griswold lasted about 4 or 5 years. It didn't last very long. It was like a way station, right? You know, like a rest stop. It was like a Bucky's based in the way to San Antonio. It was just there to stop off, get what you need, and then move on. I love that Bucky's. The bathrooms are very clean. When I first moved to Texas, to my parents at Bucky's, they couldn't believe it. I was like, wow, look at this. All right. Bucky's and Griswold. That's a new one. Okay. All right. Trish, are you next? No. Are you next, Adrian? Did you go last week? Are you next? Okay, I'm going to call on you now. All right. You want to give me the facts, please, in Griswold?
All right. So, Griswold was the director, and Dr. Buxton was the medical director for the Planned Parenthood League of Community.
Good.
And they provided information, instruction, and medical advice to married persons to prevent conception. And Connecticut had a law, the books that said that they prohibited the use of contraceptive devices, and it was illegal for anybody to aid and abet or counsel those persons to commit offense of preventing conception. So they were arrested for a time, they were convicted for counseling married persons.
Good.
And they challenged that conviction on the basis that it violated their privacy provisions of the due process clause of the 14th Amendment. And the appellate court affirmed the conviction, the Supreme Court granted cert and reversed.
By the way, everyone pronounced the word differently.
You notice
It's true. Let me tell you something. They did a study of the 9 justices. They say it 9 different ways. So if you don't know how to say it, you're not alone. Everyone, I say certiorari or certiorari, but cert is fine. If you want to say cert, I'm okay with that. In fact, Randy will not say it in the video. If you notice, he always says cert, and when he does the videos, he just won't say it because it's such a no one agrees. But Justice Breyer's like certiorari, and they all say it differently. They have the anyways. But Adrian, you're not alone. You're with us. Anyways, so very good. Thank you, ma'am. So this is what we call a test case, right? I love this photograph because it shows them getting arrested, right? And usually people get arrested, the cameras are not there, right? The media's not there, but they invited the press because they were deliberately trying to challenge this law, and they knowingly violated it. So they gave, again, advice and contraceptive care to married individuals in Connecticut. It's not clear how often this law was even enforced, and we've looked into this. This is one of those laws that doesn't really have any weight. Why? Generally, contraceptives are used in a bedroom. I mean, maybe elsewhere, but generally in the privacy of a home. I don't know. What do I know, right? They're generally used in the privacy of a home. And it's going to be the rare case where the police knock down the door and say, aha, you're using a condom, whatever, right? It's just not going to, it's going to be very rare. A similar dynamic applies for the sodomy law at issue in Laundry, Texas. Generally, that activity happens in private. Cops are not there. But in this case, they deliberately did it in public. Well, distributed the stuff in public at least. Now, by the way, why is the plaintiff Ms. Griswold and not the couple that got the products, right? So actually the prohibition was not on using it, but on distributing it. So it actually applied to the provider rather than the user, which is an important point. Exactly. Exactly. Yeah, Jeremy.
I was going to go to her point. How are they going to catch them in the act? You can't
Exactly.
barging into bedrooms.
Exactly, which is why, again, the prohibition was not on the actual using it. It was on the receipt of it, the distribution of it, which is the act that the state could conceivably regulate. All right. So they were fined, was it $100? Because they facilitated these products, right? Now, that raises a question, though. We understand that the penalties apply to the doctor, but the constitutional right being asserted is that of the married couple. How can a doctor and a director of the program, Griswold, how can a doctor and the director raise a constitutional right of a married couple, right? It's some of a disconnect, because the perfect plaintiff would be the married couple can't use this product in their bedroom, but the law doesn't punish the married couple from using it. So the court says, whatever, right? They say that the Griswold and Buckson can raise the constitutional right because of a professional relationship with them. It's a very shaky reasoning, right? That's not entirely clear. But it might remind you of another case in Pierce, right? We cited of sisters, where the teachers in the school raised claims on behalf of their students. Or the teacher raised claims on behalf of his students, right? We did that. So the court is often very flexible with who gets to assert constitutional rights. For example, in Craig v. Boren, right? Who was the plaintiff? It was the owner of the Honk and Holler grocery store. Remember the drive-through bar, right? It was the owner of the grocery store who brought the claim on behalf of the underage men. So the court moves past that one pretty quickly. I'm not going to dwell on that too much. Okay. Then we went to Lochner. And Justice Douglas says, no Lochner. We decline. West Coast Hotel. That was a switch in time case, right, with Justice Owen Roberts, right? West Coast Hotel, we are not going to go there. We're not doing this anymore. Okay? We do not sit as a super legislature. What a great phrase, right? A super legislature, right? A legislature above the legislature to determine the wisdom, need, and propriety of laws that touch economic problems, see economic, business affairs, or social conditions. But they draw the line. This law, however, operates directly on an intimate relation of the husband and the wife and their physician's role in that relation. Right? Again, the physician's not in the bedroom with them, but I guess he's intimately involved, whatever. Now again, why are intimate relations different? The court drew the line here, right? Are economic rights any less valuable than intimate rights? Maybe yes, maybe no. But the court just assumes that that's the case. They just sort of move on that front. Okay. Then they move on to the court's precedent. Say, well, we're not doing Lochner, but we have these cases. We'll talk about them. So they have Meyer and they have Pierce. Meyer was a case with the teacher teaching German, the Bible verses in German. And Pierce was where they shut down the Catholic schools. And one second, and they also shut down the military academy. Hey, Adrian.
Quick question, I just thought about something you said.
Hmm?
If Douglas is saying it's not an economic issue, it operates on an intimate relationship between the doctor and married person, but later they said that being married didn't matter.
Yeah.
Would doctors at that time have been intimate relations with a non-married couple? Like would they have, so let's say this was a non-married, well, it wasn't, okay, well, it wouldn't matter because it wasn't the couple that was,
Yeah.
okay.
So the case I mentioned, to Janice's question a minute ago, Eisenstadt v. Baird, this was a bizarre case. We had this guy, what was his name, Bill Eisenstadt? I forgot his first name, but his name was Eisenstadt. He was giving a lecture in Boston somewhere and basically handing out contraceptives to people in the audience. There was no relationship. He wasn't even a doctor. He wasn't even licensed. He wasn't even licensed. He was just handing out, it was foam, if you want to know. It was some sort of contraceptive foam. And he was just basically handing it out to people. Wasn't even licensed. And the court said, aha, he can assert the constitutional rights of the women in that room. And it was actually a First Amendment case where they have the right to speak about contraception. He was lecturing. It wasn't even a physician visit, one-on-one in the room. He was lecturing to an auditorium. Anyway, if you want to read it, it's a case called Eisenstadt v. Baird. I used to assign it. It's not in this book, so I stopped. But I'm probably spelling that wrong, but did I spell it right? Eisenstadt, was it 71s? 70?
72.
72, okay, yeah. But anyway, it's there. If you want to read it, you guys can. I know you have all this extra time to read, but it's an important case in development. So, okay, but going back to Pierce and Myers, the court says, well, Pierce and Myers were actually First Amendment cases, right? They involve the rights of freedom of association and freedom of religion. And we discussed those. That's not true. It's not. When Pierce and Meyer were decided, these were Lochner cases. These were 14th Amendment cases, due process. They weren't about freedom of religion or anything else. In fact, one of the schools was a Hill Military Academy. It wasn't religious at all. And the state statute shut down a commercial enterprise, a military academy. And no one suggested that that would violate the free speech clause or the free exercise clause. Right? But then we get to the Penumbra business, right? And I just want to focus on this for a few moments. We have this diagram in your book. For the video, I'm actually animating with like the moon moving around. It's gonna be very cool. But you have the diagram book. Yeah. What the hell? Did anyone ever take astronomy in college? I did.
Hardest class.
I liked astronomy. You liked it? No.
It's too much math.
Too much. All right. Well, fair. I liked astronomy. But anyway, I'll make this a lot simpler, right? I don't care, guys. I don't care if you know what a penumbra is or an umbra is. I could care less if you understand that. But the point that Douglas is trying to make here is that we have these provisions in the Bill of Rights that say something narrow, but they suggest something broader, right? And he walks through the various aspects of the Bill of Rights. And he says these provisions create zones of privacy. So for example, you have the right of association, which is actually not in the Constitution either. It's called right of assembly, but the court made that up, the right of association, which means you can associate with whoever you want. The Third Amendment, which we'll probably never mention again the rest of the semester, says that you can't have quartering of troops. During times of peace, during times of war, you can with the consent of Congress. In the Fourth Amendment, you have the right to be secure in your papers from government searches. Fifth Amendment, you can't be self-incriminated. All right, so he's trying to suggest that the framers understood that there were certain areas that were off limits to the government. So far, so good. I think we can all agree with that, right? That the framers, when they drafted the Bill of Rights, said there's certain areas that are off limits from the government, right? They can't search your stuff, they can't quarter troops. I think we're all okay there. But then he makes his move, right? Which comes up and I was like, whoa, where'd that come from, right? He says, this case concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. That is a very important sentence, right? Yeah, would you say, Jess, I can't hear you back there?
I was trying to figure out what guarantees mean.
Yeah, me too.
Okay, good.
Yeah, you're not alone. You're not alone, my friend. Yeah, you're not alone. But I'm going to give Douglas the benefit of the doubt. What he's trying to say is, we can give scrutiny under Caroline products if something's in the Bill of Rights. So we're going to just treat the Bill of Rights to be not just what's on the ink, but what's on the rays of light shooting from the Bill of Rights. This is the numbers, right? Like, you ever see like Indiana Jones, where like they open up the ark and these like lights start shooting out? Yeah, like that, but the Constitution, right? Where if you, but then you look at it, you turn to you melt, right? His idea is that the Constitution is, the words of the Constitution are there, but if you look at it in a certain angle, with this idea of zones of privacy, that there are these various penumbras that shoot out from it, these emanations, these beams of light. And if these beams of, oh God, I'll look at my Constitution. It's pretty dead. But you know, if, one second, Mark, I promise. But if you look at like this, right? And if you look at like, you know, there are these emanations coming out of it, then you see, wow, it's not just individual provisions, but they form a zone of privacy. And the court's job is to see, does contraception fall within that zone, right? The same way we'd say, does, you know, obscenity fall within the First Amendment? You say, does contraceptive access fall within the zone of privacy created by the Bill of Rights? So it's no longer Amendment 1 to Amendment 3. It's Bill of Rights zone of privacy. It's like this bubble, like biodome, right? Something. It's this bubble with all the stuff's going on inside. And if you fit within that, then you're still in the Bill of Rights, and you get heightened scrutiny. That's the easiest way I can explain it. I know it's not very satisfying, but I do want you to get what he was getting at. Yes, sir.
So I think essentially, this is kind of how I understand it. Essentially implying what the Bill of Rights could possibly mean.
Well, I mean, to go back to one of our favorite topics, Justice Douglas is not an originalist. We can say that with a high degree of confidence. And he's the opposite of that. He firmly believes that the Constitution has certain general principles, one of which is zone of privacy, and it's the role of judges to fit certain present-day circumstances within that bubble, that zone of privacy. So if the emanations shoot, I don't even know where, they shoot broadly enough, it gets there. So it says the law concerns a law which, in forbidding the use of contraceptives, seeks to achieve its goals by means having a maximum destructive impact upon that relationship. Such a law cannot stand in light of the familiar principle that a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms, right? He's already moving now to means and scrutiny, right? He's already moving on. But the key move is you only get to the sort of means and scrutiny once you get out of rational basis review. If you're stuck in the optical, none of this crap matters, right? None of it matters. The entire purpose of the emanations was to get out of the optical, to get back to a place where the court can use its traditional means and scrutiny. If you get to means and scrutiny, it's a very stupid law. It doesn't make a lot of sense. Justice White says, basically, this is irrational, right? Justice Stewart says it's uncommonly silly, right? I think everyone agrees with that. It's a silly law. But the most important part of the opinion is one I just gave you. The penumbras get him out of the Lochner, right? That's why he does this business, to justify it. Again, I read this every day. I'm like, wow, what am I doing with this today? But that's there. And that's it. I mean, that's the entire opinion. There's not much there. He says at the end, we deal with the right of privacy, older than the Bill of Rights, older than our political parties, older than the school system. My favorite, marriage, right? Marriage is a coming together for better, for worse, hopefully enduring, and intimate to the degree of being sacred. Again, he was married like 5 times, which is, I just have to chuckle. Maybe at this point, maybe it was 4, but eventually he had another one.
Doesn't mean he didn't mean it every time.
He does say that.
Fair point, fair point, fair point. I think that's a fair point.
He does say hopefully.
Hopefully. Good. I never picked up on that. Very good. Hopefully. Maybe next time's the 5th time's the charm, right? Yeah, Adrian.
I'm just trying to figure out what's the eliminated right?
Oh, God.
If these guarantees are hidden in the Bill of Rights, like the moon is hidden in the shadows.
Yeah.
What is illuminating it? Where
You're a smarter person than I am. I don't know.
I just can't get the analogies.
It doesn't make sense. The sun,
is bringing it out, but I can't figure
it's some sort of guiding spirit of liberty, maybe. I don't know. Don't overthink it.
I'm trying to get these extra points. Okay?
Oh man, if you figure this out, I've been teaching this for 7. Yeah. Janice and then Mai.
So one quick clarification, what Ellen was saying. So, because of the emanating,
Penumbras.
personal rights, the unenumerated personal rights, does it require a higher level of scrutiny?
Yes.
Okay.
Right, because when you're in this zone of privacy created by the Bill of Rights, you are in the first paragraph of Caroline products.
Okay.
So you're not on a rational basis. You're not in the optical world. Mai?
Can you please remind us again why they're trying to adopt the 14th Amendment?
Because they don't want to be accused of being Lochnerism, right? Justice Douglas was appointed by Roosevelt, right, in the New Deal. And the entire point of the Roosevelt appointees was to move away from the progressive court, move away from Atkins, move away from Lochner. And they can't bring themselves to embrace substantive due process. They just can't do it. So they do these other things that look a lot like substantive due process. Right, again, this structure, though, only lasts for a couple years. Doesn't last very long. It's just got him over the hump, so to speak. I saw another hand somewhere. Okay. Let me read this last part of the opinion. I'll move on. Justice Douglas writes, marriage is an association that promotes a way of life, a harmony in living. It is an association for as noble a purpose as any involved in a prior decision. So again, this is really marriage heavy. Really, really marriage heavy. That's like the core of the opinion. I'll mention this point very briefly because it came up in Loving, Virginia. It also comes up in the gay marriage cases. Why does marriage promote a way of life? Reproduction, right? What's at issue here is the survival of the human race, reproducing. And that, Douglas says, the state should not get involved with, right?
That's what makes it odd. See, what you just said, because he doesn't address reproduction or procreation. He just addressed marriage as if that's the only way babies are created.
Well, at that time, you had at that time, you had laws against illegitimacy. And I don't like that phrase, but if a child was born to unmarried parents, there were disabilities. For example, they couldn't inherit property. There were legal disabilities on married children. Yeah. If a child was born to unmarried parents, they couldn't inherit property. They couldn't have certain benefits. So those cases, again, those laws were declared unconstitutional later in time. But at this time, in the eyes of the law, the only way to have legitimate kids was through marriage. So it makes sense in that narrow context. But then the court said you can't treat, by the way, illegitimacy is reviewed under intermediate scrutiny. It's not just gender, it's intermediate, whatever it's worth. Yeah, Nisha.
So were those laws because in property, it talks about how one of the, a child can be an heir if he was born out of wedlock, but if the dad, if the father claims them and all that kind of stuff. So that means they could inherit property. So were those are like just certain states or something?
I know Louisiana had, I think it was a Louisiana case. I can't speak for all 50, but Louisiana had a law that said if you were a child of unmarried parents, you could not inherit property when your parents died. And that was designed to encourage, I'll give a preview of the gay marriage cases. We had lots of laws designed to keep married couples together to procreate. For example, divorce, right? We have today what's called no-fault divorce, which means you can get divorced because you don't like the person, irreconcilable differences, right? But there was a time where you can only get divorced if there's allegations of adultery, abuse or neglect, or abandonment. right? You couldn't get divorced for irreconcilable differences, right? That's what the celebrities say, right? That wasn't a ground. So if you got married, you're basically stuck with a person unless there's allegations of abuse or neglect or some sort of adultery. You had laws about legitimacy, right? That if you had an illegitimate child, you couldn't have certain inheriting properties, right? Even in this case, right? If you understand the framework of how laws push people towards marriage, the gay marriage case will make a little bit more sense. Maybe not a lot, but the ideas will make a little bit more sense. Once you abandon no-fault divorce, it sort of changed everything, because then it's like you can get divorced if you don't like the person. Kids be damned. Yeah.
Can you talk about the framework a little bit? Because every time I read something that says that, I think I got it in there already. So when you talk about the framework, are you just talking about the structure of the, I guess this, whatever the concept is?
You're talking about this case or general?
Like in general, because it seems like it refers to different. Sometimes it seems like it refers to the framework of the Constitution or the general. What is the framework reference?
When I think of framework, I perhaps use that phrase. I never defined it. It's what's the structure of the opinion, right? What's the structure of the case? And I think I walked through the 3 or 4 points. And if you ever watch the videos, or at least the scripts of the videos, first, second, third, fourth, those are the key points. By the way, I've updated the scripts for basically the rest of the semester. So the row script is there. They're all there. Randy and I recorded 10 things yesterday. We're through the end of the semester. Not First Amendment. Those aren't done yet, but everything until the last day is done. So you can go read those later. Yeah, we were in the studio. We actually recorded Row yesterday. We were there for 8 hours or 9 hours. The structure. Yeah. All right.
The very last person on this.
Please, please.
I wanna make sure, so he never actually applied the, what was my question? He doesn't apply the strict scrutiny test.
Does not use that word, does he?
No, he doesn't use it, and then he sort of just, that's why I said, is it the whole case, because he sort of just stops.
Yeah, it's incomplete.
The marriage issue,
Yes.
stops, and then
It's unconstitutional.
Goldberg goes into more detail.
Yes, which is why I give you those.
Okay, but he does, okay, okay.
There's no analysis, right? You know, IRAC, there's no A. It just goes IRC,
Okay, I just wanted
right?
to miss that.
It's a weird opinion, and every year I'm like, what is this? He basically says, well, you have this means, ends, and this is unconstitutional. It doesn't explain why.
Right.
The concurrence does a little bit, I think. It goes a little bit more in depth, but the majority, it's a very unsatisfying opinion. Which is why it didn't last, right? When you have an opinion that doesn't make sense, it doesn't last. As a general rule, the opinions that people still read generations as like, oh wow, that's a good opinion, they have some reason or logic to them. But these opinions, like, why is it here? It's here because it's transitioning. That's why I put it in the book. Yeah, Mia.
So the means and scrutiny for due process here is like the due process strict scrutiny.
They don't use that. Janice made the correct point. They don't use that phrase at all. When you get to Roe, they don't use the word strict scrutiny either, do they?
No, but if we had to know.
Well, the reason why I'm going to hesitate slightly is that the abortion cases use something else, and it's not called strict scrutiny. And in fact, we will not have any cases where they refer to a right as something that's fundamental warrant strict scrutiny. We just don't have those cases. The court is very inconsistent. In theory, at least, the approach the court used here is one of strict scrutiny. I think we all would agree, but they don't use that label. In Roe, I think they use what looks like strict scrutiny. To me, they don't call it that. They use language similar, but they don't call it that. So don't kill yourself trying to figure out the tier of scrutiny here.
Were we missing a justice on this case?
Were we down to 8?
Yeah.
I think we were. I think we might have been down to 8 this time. I don't remember why, but I think we were down to 8. Did you try counting? Who is missing?
We had,
No, Warren was still there.
so you had Douglas, and then you had Goldberg, Warren, and Brennan, and then you had Carlin,
Who is missing?
Black, and Stewart.
Yeah, I don't remember. Let me check who's missing on Oye. No, it was 7-2. No, they were all 9 were there. Yeah, no, it was Warren, Douglas, Clark, Carlin, Brennan, White, Goldberg, and then Black and Stewart in dissent.
So was Clark in with Douglas?
Clark was in the majority, yeah. Tom C. Clark is the only Texan justice in the court. Okay. Anything else on the majority, Justice Douglas? We'll do the concurrences in a moment. Samantha, you next?
Yes.
Oh, that was a long wait. I'm sorry. You were just waiting, weren't you? It was not nice. I'm sorry. That's mean. All right. Can you give us Justice Goldberg, please? By the way, Justice Goldberg was an interesting guy. He only served in the court for a very brief stint. He was a former union lawyer, very smart guy. But President Johnson was one of these rake deal makers. And he told Justice Goldberg, I want to appoint you to the ambassador to the UN to solve the Vietnam crisis. He got a guy to resign from the Supreme Court after a couple years to go fix the Vietnam crisis. And he took the bait. He resigned. And then then Douglas put his buddy Abe Fortas in the court, right? It was one of the, he said it was one of the dumbest things anyone's ever done. So, I'm sorry? Yeah, he was appointed to the ambassador, but the Vietnam War kept going along. He didn't end it. Anyway, and Justice Breyer clerked for Justice Goldberg in that brief time. So maybe if we need a new UN ambassador, go pick Justice Breyer to be UN ambassador. Probably not. Okay. All right, Samantha. Give me Justice Douglas, please.
Goldberg?
I'm sorry. Yes. I'm sorry, Goldberg. Thank you.
So he concurred, but for different reasons. He basically concluded that the Ninth Amendment provided all that the court needed to uphold their opinion. And he looked at the language and history of the Ninth Amendment.
Okay.
Basically saying that the framers of the Constitution believed that there were additional fundamental rights. And he also looked at Madison and Story to corroborate his belief.
Okay. Do you find, Samantha, that the Goldberg opinion is a little bit more satisfying than the Douglas opinion?
Yes.
Okay, tell me why.
It was a more logical argument. I found myself in reading it saying, okay, I can agree with that, rather than the numbers that
You're not alone.
It was kind of all over the place, but this one, it just seemed a more logical argument.
Okay, very good. So very good. Thank you, Samantha. So first off, just one slight note on this, right? Justice Goldberg does not say that the right to contraception is a right protected by the Ninth Amendment. He doesn't actually say that. Everyone thinks he says it. I thought he said it when I was in ConLaw. But go pull up the Ninth Amendment, right? It says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others, that's other rights, retained by the people. Okay? The Bill of Rights only applies to the federal government, and the 9th and 10th Amendment place limits on federal power. Justice Goldberg does not say that the 9th Amendment limits state power. He does not say that. Very important. What he does say is that the 9th Amendment reflects a recognition that the framers believed in unenumerated rights, that they were okay with the idea of some rights that were not enumerated. Now, what are those rights? Who gets to decide what those rights are? The courts? The legislature? The executive branch? It doesn't say. By the way, Randy, my colleague, is one of the world's experts in the Ninth Amendment. This is his baby. I can only pretend to do justice to it. But this was one of the first major treatments of the Ninth Amendment in the Supreme Court. They usually just don't touch it. And after Justice Goldberg's opinion, the Ninth Amendment became very popular. And if you recall in Roe, the lower court actually found that a right to abortion is protected by the Ninth Amendment. So in the span from Goldberg in Griswold until Roe, like 8 or 9 years later, Ninth Amendment went big. It's like, oh my God, we got this thing. We can protect unenumerated rights without going through Lochner, right? Who needs the 14th Amendment? Let's go to the Ninth Amendment. It was like a detour. So they got very excited. But it never really gained traction, right? 1 second, Jess. Justice Blackmun in Roe kind of just whatever, didn't really care. But it was really popular for a good 8 or 9 years until they went back to the due process. Yeah.
Okay, so when I was reading it, I sort of felt like necessary and proper clause. As we were reading it, as I was reading it, like it sort of opened up, well, gave another place to be able to not find unenumerated rights, but like using it with another clause, using it with another I don't know, I'm not sure if I can put it into words, but I kind of got the, ask me some questions, because you look like.
Yeah, I think I know what you're saying. So when you say necessary and proper, you mean it's not just commerce, but some other alternate route to get where you want to go?
There,
Oh, implied.
yes, I sort of read that as I was reading it.
So let me ask you another question then, right? What's the difference between saying something's a liberty protected by the 14th Amendment's due process clause and saying something is a right that's recognized by the 9th Amendment? What's the difference?
Well, the liberty protected by the 14th Amendment would be an express and enumerated.
Is it? Is liberty? Do we know? Does the 14th Amendment say contract? Is that a liberty interest?
No, so that would be unenumerated.
Yeah. The phrase liberty is written for sure, but we don't know what it means. Same way, the word rights is written in the 9th Amendment, we don't know what it means. So there's a very, Yarn, I'll get you in a minute, and I think Marcus had to stand up also.
I was gonna say that I said the same thing.
Okay, so let me go back, let me just give you a point. So during, we just had a Supreme Court confirmation hearing, very, very contentious. The last big contentious one was actually in 1987 or 88, which was Robert Bork. And Robert Bork was a judge who was nominated to the Supreme Court, and he was asked about the 9th Amendment. And he gave this analogy. Someone said, what does the 9th Amendment mean? What are these rights? And he said, well, it's as if we have the Constitution and someone put an ink blot on it. And, I don't know what's under that ink blot. And that's the 9th Amendment, right? How am I supposed to know what's under that ink blot? Give that answer. Now, there's a lot of evidence, which you might like, about what the unenumerated rights meant at the time of the framing in the 1790s. That's one way to interpret it. Or you can do what Justice Goldberg does, say, well, these rights retained by the people aren't fixed in stone, and they are more modern. Right? But once you say that these rights are more modern under the 9th Amendment, is there much of a difference between that and Penumbras? Right? If we're saying that the rights are what we recognize as judges, does it matter if it's due process? Does it matter if it's Penumbra? Or does it matter if it's liberty under the 14th Amendment? What difference does it make? All roads lead to the same place. And that's what the sort of Warren Court approach is. You can have 3 or 4 different roads and they'll get to the same place. So like Justice Blackmun says, well, maybe it's the 14th Amendment, maybe it's the 9th Amendment, maybe it's privacy, whatever it is, abortion's in there. It's big enough to include the right to abortion. Right? That's what he says. It doesn't really matter which road you choose because the text is not important at that point. Yeah, Mia.
So when I read the part about the 9th Amendment, as he continued on, it sounded like he used the 9th Amendment to bolster using liberty under the 14th and 5th. Is that right?
Yeah. His point was, again, and this is in tension with Caroline Products, right? Caroline Products is in tension with the 9th Amendment. Caroline Products says if it's in the first 8 amendments, we protect it. If it's not, we don't. The 9th Amendment says the mere fact that it's unenumerated doesn't mean it goes unprotected. Right? Again, Caroline Products says you have to write it down. If you don't write it down, you don't protect it. 9th Amendment says if it's not written down, you still protect it. Right? Caroline Products is in tension with the 9th Amendment. Here, Goldberg's pushing back on Caroline Products. He's pushing back on it. And he's saying, look, we have the 9th Amendment. Maybe these zones of privacy, these penumbras are real. He doesn't quite use that same language, but he suggests, maybe it's there. But then he says, how do we recognize what rights to protect? He says, well, it's not based on our personal private notions. We look to our traditions and collective conscience of people to determine if a right is rooted to be ranked as fundamental. He says, if the right involved is of such a character that it cannot be denied without violating those fundamental principles of liberty and justice, which lie at the base of our civil and political institutions. Tim, what's he getting at there? What the heck? He's saying, look, we can't just make crap up. We have to be guided by tradition and some sort of history, right? How are we to know what that is? How can a judge know what that means?
Well, as he goes through and he's talking about the traditions, it's just looking at what's happening in history, what's happening in society. It's very vague and very nebulous, but...
So if we're looking to tradition, right, the courts can recognize liberty interests that are deeply rooted in tradition. What if I told you that dozens of states had bans on contraception?
Yeah, well, he goes back and looks at common law, and that should be in the tradition, but it's weighing that right against the right of privacy that they're coming up with within the Penumbra.
So, I mean, here's the tension, right? If there's some right that's so deeply rooted in our traditions, then it's going to be protected by the democratic process. The reason why they're in court here and not in the Connecticut state capitol is because the law is in the books, right? In other words, if we start saying we protect deeply rooted rights, that will only matter, say there's like 49 states that go one way and one state that goes the other way, right? Fine. But if you have 46 states have bans on abortion, we'll get there in a minute, it goes the other way. Now, fun footnote, Connecticut actually repealed the statute. And I believe they repealed it while this case was pending or shortly thereafter. So they didn't even need this court decision. Connecticut was actually going to repeal the statute. Right? They were going to repeal it. So that's why the opinion is really irrelevant. Connecticut basically repealed the statute. I think it might have been repealed in one house of the Connecticut government. I might be missing up the facts, but they were basically repealing it. All right? Anyway, so that's Justice Goldberg. Who's next? Dusty. You want to give me Justice Harlan?
Justice Harlan.
By the way, this is the grandson of Harlan the First. Remember the guy from Plessy and civil rights cases? That was Harlan the First. This is Harlan the Second, his grandson. All right, go on.
He agreed with the reversal, but he said instead of relying on the implied right of privacy in the Bill of Rights with the bubble of the first Native Amendments, the right of use to use contraception in marriage is supported by the due process clause of the 14th Amendment.
Yeah, the 14th Amendment, due process standing by itself. How is it different than Lochner? It's not. Right? Lochner was straight up 14th Amendment. He's saying, look, let's cut the crap and let's just rely on the 14th Amendment. Okay? Don't go to these penumbras and radiations and all this other stuff, right? But then he says, look, we need to have restraint. We need to restrain judges. We need to have insistence upon respect for the teachings of history, solid recognition of the values of our society, and appreciation for the roles of federalism and separation of powers. Again, what does that mean? I don't really know. But they're trying to say we can't just make crap up. We have to have some sort of limitations on us. What? Oh, you raised your hand a minute ago. I didn't call on you.
Oh, you ended up answering.
Good. But you want to say something now or no?
No, I just said they
Okay. All right, guys. Fun. Guys, okay.
Enjoy the system when it works, but I guess my problem is when they expand their powers, they expand the laws to do things that I think are better for society. But what about like the judicial? I guess I worry about judicial restraint when it doesn't better society, when it's for the worse. So when it works, like in Lincoln, the Emancipation Proclamation, I thought it was genius, and I loved it. But if a president uses it for something that's not as good, is when
it's dangerous when power is held by the hands of someone we don't like and don't trust. It's a fair point. Yeah. All right. Gerald, do you want to give me Justice White, very, very brief one?
Yeah, so he starts off by saying that the Connecticut law applied to married couples deprives them of liberty without due process, as that concept is used in the 14th Amendment. He talks about how, in his view, the statute with these effects bears a substantial burden of justification when attacked under the 14th Amendment. What I took out of it was more of his argument was in further into the 14th Amendment's due process.
So Jared, let me ask you this question. He actually has analysis in here. He actually does some analysis, which is important. Why does Connecticut ban married couples from using contraception? Why would Connecticut ban a married couple from accessing contraception? And by the way, this is just the wife we're talking about, right? Why do they ban the married wife from having contraception?
Fear of conception operates as a deterrent to such
Deterrent of what?
Of such relationships in addition to the criminal.
What are such relationships?
Like,
What are they, what's the state worried about here, right? Why? Yeah. Adultery, thank you, yes. Adultery. Guys, shh. The thinking here was, well, if we let married women have access to birth control, they're going to go sleep around. That's actually why the law applied only to married women. Because if they have access to contraceptive, they're more likely to have an affair. But Justice White says, guys, please, one at a time. Yeah.
It's the opposite, that they were worried that if they gave the married women contraceptives, the married men would look for opportunities with women. Not that the women would, not that the men would have to have affairs with someone, but it wouldn't be the.
It'd be other married women.
Correct. The female on the contraceptive that was looking for the opportunity as opposed to a man thinking, oh, now I don't have to worry about getting someone pregnant. That gives me more opportunities.
Oh, I see your point. Well, okay. Well, I don't think that's how Connecticut thought about it, but maybe that's right. But let me. I'll call you in a second. Let me just make this point. Justice White says, I fail to see how the ban on the use of contraceptive in married couples reinforces the state's ban on illicit sexual relationships. He's doing means end scrutiny there. He's actually doing some lifting. He's saying, look, if your goal is to stop illicit relationships, you're doing it in a stupid way, in a way that makes no sense. That's what I think Justice White, if actually during Kavanaugh's hearing, someone asked about Griswold, he said, I agree with Justice White. He said that very carefully. He said, I agree with Justice White. I don't know who's next. Kenesha?
So is that like the, so I think like in Carolina, one of the Carolina, that it's illegal to, like still, it's, you can sue, like if you're married and then somebody cheats or whatever.
Alienation of affections?
Maybe, I don't know. But you can sue the mistress or mistress.
Yeah, it's a tort.
Is it like that?
It's a tort that exists in several states. I don't think it's constitutional, but it's called alienation of affections. You do that in torts? Where basically if you seduce someone, right? If someone seduces someone's wife, the husband can sue the seductress, whatever it is. Seductor, yeah. Can sue the seductor, however it happens to be. Yeah, I don't think that tort's constitutional anymore. But at the time this case was decided, adultery was a crime.
Well,
Adultery was a crime at this time.
But like now.
No.
Yeah, like a couple years ago, because like Fantasia, I think, maybe like a singer. A few years ago, she had an affair with some man, and his wife sued her.
Well, that's not a crime. That's civil. But I'm saying at the time, adultery was a straight up crime. They could throw. Frank Sinatra. Google this. Google this. Frank Sinatra was arrested for engaging in adultery. I swear. He stepped out with a married woman, and they actually arrested him. The mugshot of Frank Sinatra. You've seen it. It was for an adultery charge. I swear. Google this. Just Google this. I'm telling the truth. He wasn't prosecuted, they let it go, but he was actually arrested for carrying out the married woman.
So you're saying the criminal ones are unconstitutional, but when it's the civil...
I don't think the tort's legal either, but they're still in the books. The criminal prohibitions in adultery I don't think exist anymore. But the civil tort of alienation of affections is still there.
I'm gonna let you know.
Google, I'm pretty sure. Yeah. Yeah, anyway, you've all seen the Frank Sinatra mugshot, yeah? Yeah. It's a very famous mugshot. Yeah, he was a young guy. Yeah. He was arrested somewhere in Jersey, basically for carrying out the married woman. Bergen County, thank you, ma'am. All blue eyes, right? Okay, anyway, back to our thing. Oh yeah, Yaron, go ahead.
So when it says deprives them of liberty without due process of law, just to be clear, due process in the sense of like rationale?
Yes, this is the lottery, right? This is not process as in procedural. This is saying that no amount of process can justify putting someone in jail for using a birth control condom, right? By the way, the stuff back then was not very effective in the 1950s, so it wouldn't do much as a deter reproduction, but it did what it did. Yeah, in the Eisenstadt case, it was actually foam. It was this can of. Was it a movie? Was it like that movie with the foam? I can't. There was a funny movie made about it. I don't know. Anyway, Frank Sinatra was arrested by the Bergen County Sheriff for with a married woman. Yep, there it is. I think I used that exact phrase. I think I had read this in my head. They were carrying on somewhere. The dissents. Okay, who's next? Yeah, no, I know it is, and I don't think they're constitutional.
Oh, you don't think they're constitutional?
No, in other words, if Eugene Volk, who's a law professor at UCLA, writes about this, and courts allow these torts to go forward. I don't think they're valid under current law.
Well, but you mean so help me.
Yeah.
It's clearly valid under that state's current law.
If a state has a statute on the books, that doesn't mean it's constitutional under current Supreme Court doctrine. There are lots of laws that are on the books that aren't valid.
Because
they've never been repealed, right? You have laws in the books that have never been repealed. Never been repealed. Right? In fact, there's a good segue to abortion in a minute. A lot of states still have criminal prohibitions in abortion. Now, to enforce them would not go anywhere because of Roe and other cases. Massachusetts, about a month or two ago, actually repealed their criminal prohibition on abortion. Said, well, if Roe's overturned, we have this book in our... So they actually repealed the statute. Good. Clean up old statutes that you want anymore. It's a very good plan, I think. Don't keep old statutes.
Sodomy is still...
In Texas, the prohibition was declared unconstitutional in Lawrence v. Texas is still in the statute book with a notation saying declared unconstitutional. And several states still have them on the books. I have an entire paper on this. Okay. All right. Diana, you want to give us the Black dissent?
Well, he states, and Stewart, I guess, states that the amendment is not passed because then the court promised before that there are limits to federal government.
Okay.
And then the rest of the opinion kind of states that since reasonable minds can disagree, it's not for the court to decide. That's enough.
Yeah, I mean, this is basically, the Harlan dissent in Lochner, right? The state has a reason why they want to have this law deterring adultery. We might think it's a silly reason. It's probably enough. And it's not the business of judges to substitute our wisdom for that of the elected branches. By the way, so this is Black and Stewart, right? Stewart, by the time you get to Roe, comes around and says, you know what? I'm moving on. I accept it. Right? Stewart wouldn't accept substance here, but he accepts it by the time you get to Roe. Okay. And commonly silly law, as he calls it. Justice Thomas, just keep it in mind, he calls the abortion statute Texas, Lawrence v. Texas, commonly silly law. Uses that same phrase. All right. Any other questions? Again, it's not important for what it says before what it does, as far as how it moves the doctrine along. Because by the time you get to Roe, they just go in a totally different direction. Yeah, Aaron?
They basically just use the Ninth Amendment because they just didn't use the 14th.
That's one answer, possibly. I don't think Justice Goldberg would see it that way, but I think that's a reasonable way to read it. Was another hand? All right, so let's move on to Roe. Most cases, or very few cases, are known as well as this one. This one has a resonance, a salience, unlike almost any other. You have maybe Brown, maybe you have Roe, maybe you have Marbury, right? There are a handful of cases that almost everyone knows the name of the case. They don't know what it actually says, right? Like Marbury did not invent judicial review, Brown did not overrule Plessy, and Roe didn't create a right to choose. It did something very different. So the case itself and the facts of Roe are they're sad. And if you ever want to look at a person who I think was abused by both sides, it's Norma McCorvey. I'll tell her story. She actually died about a year or two ago in Sugar Land or somewhere in this area. She was living here. So she was in Dallas in the 70s, and she became pregnant with her third child. she tried to obtain an illegal abortion at the time. The clinic had been shut down. Then she admitted this. She made up a story that she was raped. Because in Texas at the time, if you were raped, you were able to obtain an abortion. But she made that up. Then she got in touch with these lawyers. And these lawyers were looking for a plaintiff. And they needed someone to file a lawsuit challenging Texas's abortion statute. Now, Norma McCorvey, all she wanted was an abortion. That's what she wanted. And those lawyers could have gotten her one, right? They could have facilitated it, but they didn't. And she later said that they misled her, right? All she wanted was to terminate the pregnancy. She couldn't do it. But they needed her, because if she wasn't pregnant, she couldn't be a plaintiff in their case anymore. So ultimately, she carried the child to term and put up for adoption. So the child was born and then put for adoption somewhere. But she was basically used as a plaintiff. In the 1970s and 80s, she became a very famous advocate for the pro-choice movement. And this is actually Gloria Allred back in the day on the steps of the Supreme Court, and here's McCorvey. But at some point in the 90s, McCorvey began having second thoughts. Indeed, she was an open lesbian, and she had an open lesbian relationship. And she became a born-again Christian and broke up with her girlfriend and was baptized and became a staunch advocate for the pro-life cause. So, I mean, she was on both sides. And it's a sad story because I think both sides used her in an unfortunate way. The pro-choice movement used her as a figurehead, but they didn't really care what she had to say, and they sort of just made her go to these events. And they didn't treat her the best way. And then the religious groups didn't treat her well either, because like, oh, we have Jane Roe, who's now pro-life, and she died about a year or two ago. She had some sort of I don't know if it was dementia, but something in that ballpark where she didn't really have her full senses with her. So it was not a happy life for her. You know, her name was on the case. Her name was Norma McCorvey, but it was called Jane Roe. Yeah, it's not a good picture for her either way. But later in life, she came to regret it, and she worked in her later years to try to overturn the case that she helped put forward. All right. So, any questions about that? Yeah, if you just pull up her her obituary in the New York Times, it's pretty good. It summarizes her life, I think, pretty neutrally, if you want to read more about her. Okay. I'm sorry? You know, I don't know. That's a good question. I have no idea. What a good question. I've never thought about that. Usually the adoption records are sealed pretty tight. Yeah, I don't think they'd want that baby to know who she was or he was. Okay. All right, who am I up to? All right, you want to give us the facts in row? Just the facts, ma'am. Sir. You know the expression. What show was that? Just the facts, ma'am? Was that Dragnet? Dragnet, yeah.
The Texas Penal Code restricting legal abortions to those procured or attempted by medical advice for the purpose of saving the life of the mother.
Okay. So that was the only exception, right? Right. Okay, but just to caveat, it was for the life of the mother, not necessarily the health, which means basically the mother would die. Not that, you know, it might make her sick or might be whatever, die. Okay, go on.
Jane Roe, pregnant single woman, she brought suit against a Dallas prosecutor, Wade, on the grounds that the statute was unconstitutional, restriction on her right to obtain an abortion. The federal court issued a declaratory, but not an injunctive release, stating the statute is void for overbreadth, vagueness, infringement of 9th and 14th Amendment rights.
More than that. They said the 1st, the 4th, the 5th, the 9th, and the 14th Amendment. And then, wait a minute, Josh. The 4th Amendment, they argued that a law mandating someone to carry a child term was a seizure of her body. And they may have had, I think, even a takings claim that was actually taking of her body. In fact, don't laugh. In fact, there have been 13th Amendment claims that forcing women to carry a child term is a form of slavery. There have also been 13th Amendment claims about Shamu, that, I'm serious, that the people, what are they called, was it Blackfish, the movie about SeaWorld, they've argued that forcing a whale in captivity is a form of slavery, because it's not limited to persons, that slavery shall not exist. So, yeah. So anyway, yeah, they brought the entire kitchen sink against them, right? All right, so thanks, Mark, that's good. So they basically brought the entire kitchen sink, and the district court found that's protected by the 9th and the 14th Amendments. I've never actually read the district court opinion, probably should, but I can't imagine it's probably very Penumbra-ish. It was the 70s, nothing really mattered. All right, what did Robin Williams say? If you remember the 70s, you weren't there, which I think is a fairly good description. I wasn't. So then we have Justice Blackmun's opinion, and this is an opinion that's somewhat unique. It doesn't resemble a lot of other opinions you have, and it's actually really long. I mean, your expert is pretty long, but it's a really long opinion. And originally, it was decided once and argued a second time after 2 more justices joined the court. But I want to read the introduction. And he says, we forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and of the deep and seemingly absolute convictions that the subject inspires. Let me pause there for a moment. Today, abortion is a very divisive issue, probably the most divisive issues we have. Believe it or not, in the early 70s, it wasn't as controversial as it was today. It wasn't. The Republican Party didn't really have a strong stance on abortion. Except for Catholics. Most Christians didn't really have a strong stance on abortion. Most states were moving to liberalize their abortion laws. That all changed after Roe. There was a huge backlash to the decision. The Evangelical Party, the Evangelical movement, the Republican Party, largely grew in response to the Roe decision. Most of the judges in the Roe majority were actually Republican appointees. It wasn't the sort of social issue it is today. Okay, he goes on. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitude towards life and family and their values, blah, blah, are all likely to influence and color one's thinking and conclusions about abortion. Right? Then we get to this next sentence, which I always pause. He says, in addition, population growth, pollution, poverty, and racial overtones tend to complicate and not to simplify the problem. Kristen, what's he talking about there? I know. What is he getting at there?
I'm trying to take personal bias out.
Answer however you want. We're all friends here.
Basically, that certain races kind of have unprotected sex and have an abundance of children, and so it's kind of like a cop-out to like allow them to have abortions, and so they want to strict
Sergio, what do you think he's getting at here? I think you're on the right track. What's he getting at here?
I think it also has to do with eugenics.
Give me more.
Well, because like in Buck, if you sterilize so she won't have any more children, the same thing you do with people that are either poor or racial or that is undesirable. You just give them access to abortion so they don't reproduce.
Yeah, it's a little bit easier than sterilizing them, right? Right. Or is it not? I don't know. So this is a passage that is very tough to read, especially in 2018. But when this was decided in the 70s, it was a very different world. So I'll just take them one at a time, right? Population growth, pollution, and poverty. In the 70s, it was a very common theory that the world was going to end due to population growth. We don't hear about this today, right? But if you watch old PSAs from the 70s, yeah, they were worried about overpopulation. We'd run out of food. We'd run out of oil. We'd run out of resource. Now, all those people were wrong. There was a famous book called The Limits of Growth or The Population Bomb. it was all junk science, right? These things are just not accurate, right? Human ingenuity always finds new ways of creating food in more efficient fashions, and we can have bigger populations. We're not going to run out anytime soon, right? That's just not going to happen. But what he's basically getting at here is, if our population gets too big, we may need to turn to abortion to deal with that. I think Chris and Sergio are both getting in the same direction there, right? And then the racial overtones, I think, is along the lines of Kristen's point, that there might be some races more likely to get these than others. He put that there on the first page of the opinion, right? No one made him put that there. So it's a very bizarre thing. And I'll note, Sergio mentioned Buck. Buck v. Bell is favorably cited in Roe, right? It's like, whoa, where the hell did that come from, right? You're reading Buck v. Bell.
Can you say that? I didn't understand what you said.
Roe cites Buck v. Bell favorably. Okay. Like, not like with a red flag on Westlaw. It's like a green flag, right? Just to make it understandable, right? It's saying that the state has an interest in your reproductive rights. It's not just about whether the state can allow you to have an abortion, but there might be cases where the state can prevent you from reproducing. So I think Sergio was alluding to this before. Look at China, right, which has basically forced abortions for wide numbers of people. Mandatory. Right? I mean, this was going on in the world at the time. China was overpopulating. So he's writing in a very different time that it's hard to relate to it, but I just want to put you in that worldview. Then he goes on. But we decide this case based on the Constitution, free of emotion and predilection. Now that we got that out there about abortion and eugenics, right? We just put that out, and we're all friends here, right? Then he says, we're like Justice Holmes, which I guess is Buck v. Bell, right? He says, the Constitution is made for people of fundamentally differing views, and the accent of our finding certain opinions, blah, blah, blah. Lochner, right? So again, they're still clinging to the idea that we're not doing Lochnerism and that we're not having this sort of judicial insertion of their own morals, right? All right, so any questions in that introduction? I don't think Randy had that part in his book in the second edition, but I made him add it because I think it frames it in a weird way, and I don't. Every time I read it, I sort of feel differently about it. But it's very strange. Again, whenever you read these famous cases like Brown or Roe, it wasn't what you expected, right? Right? Yeah, it was not what you expected at all. It's often the case that these landmark decisions, like, wait, what did I read? All right, one brief point. The issue is what's called standing. Generally, you can only go to federal court if you have standing, that is, if you're injured by the law. But the very nature of the pregnancy is unique, and that lasts at most 9 months. And generally, it takes more than 9 months to get to the Supreme Court. So can it be that by the time you get to the court, you gave birth, that means the case is moot. The case is moot. You got to dismiss it. So the court develops this doctrine, which is somewhat strange, but I want to type it out. It's called capable of repetition, yet evading review. I mentioned this briefly. And the idea is this. If there's some problem that keeps repeating itself, but because of the limited duration of a term of pregnancy, 9 months, you can't get to the court in time, the court keeps it. So even though Jane Roe, Norma McCorvey had given birth, they kept the case. If you have a problem that keeps repeating itself, it's capable of repetition, but it evades review because the term of pregnancy lasts only 9 months, the court will keep the case. Okay.
But it doesn't only apply in the context of pregnancy.
It's not only pregnancy, but that's the most common application. It applies in a few other spots. Okay. All right, so now we get to legal analysis, right? The most important precedent we have here is Griswold, right? But again, Griswold was all about a right of privacy in the marital bedroom among married couples. Now, they got rid of the married part, but still about a right of privacy. But there's something different, right? Contraception is something that you use during intimacy in a bedroom or somewhere else. Abortion is not done in a bedroom. It's done in a medical facility with doctors or nurses or other professionals. So the nature of privacy has to change a little bit, right? It's not about the intimate relationship, but it's envisioned as a privacy about what you do with your own body. Again, that was not the basis of Griswold. Griswold's about marital relations, but here it's about you have some right to choose what you do with your body. So there's a shift here. The court's analysis, though, tries to explain that the rationales for abortion don't add up. So, Clay, what are some of the rationales that the state advanced for why they have this prohibition on abortion? All right. Why? In other words, why would the state want to restrict abortions? What's some of the reasons why a state might want to restrict abortions? Give me one.
The interest of the child.
Yeah. So Justice Blackmun writes, the state has an interest in protecting prenatal life. Right? There's a second interest that's usually more obvious, is safety. Right? The state has an interest in regulating all medical procedures so that people are treated in a safe fashion. The conditions are clean, people are licensed, stuff like that. There's another interest which the court doesn't really consider, which is discouraging illicit sexual conduct. Texas doesn't rely on it. That's the one we mentioned before, right? That if a person knows that she can get an abortion, she's more likely to engage in sexual relations, and that promotes it. Therefore, by eliminating abortion, women might be less likely to engage. The court and Texas doesn't really pursue that. So we have these two interests, right? One is safety, health of the mother. Second is the protecting prenatal life. Okay? So Mia, what is then the basis of the state's ability to protect prenatal life, right? Why does the state have that power as a general matter?
So they talk about the competing interests of the, is that where you wanted to go?
No, my question is more simple, right? What gives the state the power to protect prenatal life?
Well, they call it potential life, and so at a certain point, it is a living.
But again, what gives the state the power to enact that law? The question is a bit more simpler.
Oh, they say it's their duty.
Duty, Kristen?
States have the rights to protect the general welfare of their people.
And what's that called?
Police power.
Yes, good. Yeah, police power, right? So the state has a general police power, right? To protect the health, safety, welfare, and morals of the people. Now, I don't think I've read to mention this before, but is the police power limited to people? The answer is no. We have animal cruelty laws, for example, right? Which protect puppies and kitties, which are not people. So the state's police power can be based simply on morality, right? We think it's immoral to abuse animals. We think it's immoral to harm a fetus, an unborn child, right? So the state has the police power to protect the unborn. Again, that doesn't turn on the 14th Amendment. And Justice Black makes a big fuss saying, aha, only people born are citizens. Well, you can be a person who's not a citizen, right? If all persons who are born are citizens, then an unborn person can be a person who's not a citizen. Indeed, at common law, if you were in utero, you can inherit property. For the rule against perpetuities, right? Remember this. If a child is in the womb, that counts for life and being. He doesn't mention the rule against perpetuities, makes his prop professor sad. But if you're in utero, that's a life and being for 21 years. You can count there, right? I will not mention rap again, I promise. I torch one class, won't torture second class with it. But the state has this interest in protecting things they consider morally offensive, and maybe they have an interest in abortion. But then we have the 14th Amendment and the Due Process Clause, right? So, Noel, what argument does Justice Douglas make that the right to terminate a pregnancy is within the liberty protected by the 14th Amendment?
What Justice Douglas says is when he confers is that the right to an abortion.
No, the majority.
Oh,
I'm sorry, Justice Blackmun. I'm sorry. I meant, no, Justice Black, majority.
okay. Can you repeat the question?
How does Justice Blackmun, the majority, find that the right to abortion is protected by the 14th Amendment? What's his argument?
Well, he's saying that it's not explicitly mentioned, but that it's protected because it's in a zone of privacy.
Okay. Now, is that based on penumbras and emanations and other stuff? Does he go through that entire astronomy deal?
No.
No.
Not the entire thing. It just says that, those rights are limited. But there are fundamental rights.
Okay, fundamental. That's what I'm looking for. Okay, good. He says that the right of personal privacy includes the abortion decision, right? And that where certain fundamental rights are involved, the court held that the regulation limiting those rights can only be justified by a compelling state interest, and that legislative enactments must be narrowly drawn to express only the legitimate state interest at stake. That's basically the test for strict scrutiny. He doesn't use the word, but that's a strict scrutiny test. And what he's saying is that when you have the right to abortion, which is within the zone of privacy, you apply strict scrutiny to it. But he doesn't apply it in the usual way. He says that this right is not unqualified, and you must consider it against important state interests and regulation. And this is where the trimester framework comes into play. Right? We all know a pregnancy is 9 months. There are 3 trimesters, months 1 through 3, 4 through 6, 7 through 9. Right? Simple math. And what Justice Blackmun suggests is that the woman's right to privacy is strongest earlier in the pregnancy. And as you move towards the 9th month, that women's interest declines. He also says that the state's interest is very weak at the beginning of the pregnancy, but the state's interest becomes stronger as you get closer to the 9th month. Now, why does he choose these 3 months in this trimester framework? I have to agree with one of the dissents at this point. It looks like legislation, right? If you were trying to draft a statute, this might be a sensible statute. It's very administrable. It's easy to apply. But where he gets us from, it doesn't read like the usual decision of a court. Okay? So let's walk through the 3 trimesters, right? In the first trimester, the state has an interest in protecting the mother's health. So therefore, they can regulate medical facilities, they can license doctors, cleanliness, that sort of things, right? But in the first trimester, the state doesn't yet have an interest in protecting fetal life. Why? Fuzzy reasoning, but the baby's too young, right? The fetus is not developed enough. So in the first trimester, the state only has an interest in regulating health and safety, which means they can license doctors, they can license facilities, but they can't ban it. They can't ban a first trimester abortion. Okay? That's the first trimester, so months 1 through 3. Okay? But then we get to the second trimester. Okay? In the second trimester, that is months 3 through 6, or 4 through 6, the state does have now a strong enough interest in the mother's health. The state has a strong interest in fetal life. but you still can't ban, right, abortions in the second trimester because the interest in fetal life is not yet strong enough. So again, first trimester, you basically have just straight up qualifications, right? The second trimester, you can regulate to maternal health. But then you get to the third trimester, which of course is subsequent to the viability point. Again, they presume that viability is at the sixth or at the end of the second trimester. This is a thing that science will change. And I always ask this question, people always argue about what the point of viability is. I don't want to know what the answer is, but it changes, right? The number in 1973 is not what the number is today. That neonatal care is very different than it was 35 years ago, or 40 years, whatever it is, 40 years ago, okay? But after viability in the third trimester, the state may, to promote the potentiality of human life, can regulate and even ban abortion, except to preserve the health and life of the mom. Okay? Yeah, I'll say it one more time. And if you want to read it, at the end of his opinion is his press release. I call it the press release, right? You never see it. It's basically a bullet point of the 3 trimesters. So just, I'm going to read from there. It says, in the third trimester, subsequent to viability, the state may promote potentiality of human life, may regulate and even ban abortion, except where necessary for the preservation of life or the health of the mother. Okay. Monique, yeah.
What is, I don't get the difference. You said it, I just missed it. What is the difference between the first trimester and the second trimester?
In the first one, right? In the first, basically it's a decision between the doctor and the mom. Only the state can do is regulate qualifications for being a doctor and stuff like that. There's no actual specific abortion restrictions they can impose. In the second trimester, we'll have cases later involving, for example, mandatory sonograms, for example. Things of that nature about the health of the mother so she's informed. Right, but under Roe, here, let me show you this one. This is the front page of the New York Times. LBJ actually died the same day Roe was decided, so it wasn't even the top billing. But the headline is, High Court rules abortions legal the first 3 months. The upshot is during the first trimester, the state can't do anything to regulate abortion beyond licensing doctors in the usual course. In the second trimester, there might be some specific things for maternal health, but they can't do that till the second trimester. Make sense? Noel?
So did I understand correctly that at the beginning, before Roe, the mother's health was not
You asked about the Texas statute?
Yes.
Under the Texas statute, a woman can get an abortion if her life was in jeopardy. But that's not the same thing as her health being in jeopardy, right? So for example, what if a mother needs, radiation treatment for cancer, but that would kill the child, right? What if having the child would give someone really bad hip pain that they would become immobile, right? So the person would probably survive, but will be severely weaker and sicker perhaps in the future. So the difference between life and health can sometimes make a difference. Yeah, Yarn?
Is it through these regulations that they later do the your husband had to agree with you getting?
That's Casey. That's the reading for Wednesday. We'll do that. We'll do the husband consent provision on Wednesday. Yeah, and if you don't like this trimester thing, don't worry, it's not law anymore, right? This, the biggest, keep abortion legal, save Roe v. Wade. Roe was overturned like 30 years ago. It's not good law anymore. You'll see why when we get to Casey, but it's not good law anymore, right? It's not. For Roe, the trimester framework does not exist anymore. It hasn't existed since 1991. So if you don't get it, don't worry about it too much. I mean, you have to know it, but it's not current law. Okay. Is So any questions on the majority? Again, I didn't focus too much on the reasoning because it's not as important. But the court competes, right? You have an interest in prenatal health and the interest in the mother's health. And then you have the mother's interest, and they basically try to balance it out over the 9 months of the pregnancy. And that's how they get to this point. So any questions on the Roe decision, majority? Be sure to check for Casey the script. It's now linked on the syllabus. So just if you haven't already, you'll be able to see it for next week or next class. All right. Anything else in the majority? Okay, the concurrence, you have Justice Stewart, right? Yeah, Justice Stewart, again, he dissented in Griswold. And he says, you know what, I've come to accept that this statute violates the liberty provision of the 14th Amendment, and I'm okay with it. You don't have Stewart? Who do you have? You have Douglas? Oh, I never remember what's, because I know the case myself, and I don't remember what's in your book. I'm sorry. It's not your fault. It's not your fault. Don't worry about it. It's not your fault. It's not your fault. Anyway, Justice Stewart said, I accept substance of due process. Don't worry, it's not your fault. I know the case, so I don't always remember what's in your book. All right, who's next? Quinn, you want to walk me through Justice Rehnquist's dissent?
So he said that privacy was not involved in this case.
Mm-hmm. Why is privacy not involved?
He said they should have focused on some other areas to find their.
But why does Rehnquist think an abortion is not private, as opposed to, say, maybe contraception?
Maybe something with the intent of the drafter is working.
No. Simple answer. Is an abortion private in the same way contraception is? No, it's a medical procedure. There's a doctor, there's a nurse in the room, right? You go to a hospital to do it. So what Rehnquist is saying is this is not private. It's not privacy, at least the way Griswold understood it, right? And then he says he would review the Texas law for the same standard as Aleoptical, right? And so long as there's an exception for the mother's life, not health, but life, he would find the statute valid. And then he goes Lochner on him, right? He says, you guys are Lochner, Marsha, right? This is judicial legislation. And you're not trying to figure out the intent of the framers of the 14th Amendment. He adds that states have restricted abortion for nearly a century. And to be blunt, I mean, abortion, it's existed for a very, very, very long time. There are different potions that the ancients would take to terminate pregnancy. This is something that existed for a very long time. Only in the 20th century to become a surgical procedure you could actually do, and the person wouldn't die from bleeding with any regularity, but this has been around for a long time. And states didn't always criminalize abortion. But the fact that they didn't criminalize it doesn't mean you had a right to it. And there's a conflation, right? So if there's some activity that was simply not criminalized, does that mean we have a right to it today? That's the deeply rooted part. He says views on abortion are changing, but the fact there's a debate means it's not universally accepted. And as a result of Roe, I think almost 40 states had their laws declared unconstitutional. So it's a pretty sweeping decision. All right, so any questions on the Rehnquist dissent? Rehnquist was brand new. I think he'd been in the court there for like maybe a year or so. Yes, Sergio?
Just a side question. When did the doctors stop taking the Hippocratic Oath?
Have they stopped?
I mean, because abortion is mentioned in the Hippocratic Oath.
Yeah, what does it say about it?
That they are not to assist in...
Is that what it says? I don't know. I don't think that's right. In fact, Justice Blackmun makes a really big fuss on the Hippocratic Oath. And I don't think abortion's inconsistent with the Hippocratic Oath. Just Google me on that one, right? I might be wrong. But Justice Blackmun is a really, we edited your book for your sanity. But Justice Blackmun has this long discussion on the history of the Hippocratic Oath. He was formerly the lawyer for the Mayo Clinic in Minnesota. And he spent an entire summer there researching abortion. And the opinion's long. It goes through all this history, which I read at some point in my life, and it's long. But if you want to read, just bring up the full Roe opinion, just search for Hippocratic, and you'll see it discussed. Yeah, Mia.
This is later addressed, I think, by Blackmun, in a case that we read for Wednesday, but
Casey?
he says that the 14th Amendment, because it's not well settled and there's still a debate on it, and the laws for like abortion laws are on the books, that it's not deeply rooted in the conscience of the people and therefore isn't ranked as fundamental. But the 14th Amendment was ratified because there were laws on the books and there were deeply rooted issues that there was a controversy as to what was fundamental. So I don't understand the argument. Is it that he's saying that the 14th Amendment doesn't apply here because it's not private? Or is he saying that the 14th Amendment doesn't apply to issues that are not fundamental because it's not well settled?
Are you talking about Rehnquist now?
Yes.
I think Justice Rehnquist would respond that the framers of the 14th Amendment weren't thinking about abortion at all, right? It was a provision designed to eradicate white supremacy and eliminate slavery. And reading it to protect these sort of evolving rights is inconsistent with the judicial role. Justice Rehnquist hates Lochner as well, right? He thinks that all these cases should be reviewed for minimum rationality. As long as these laws aren't completely insane, they should be valid and upheld. Right? I think Justice Rehnquist would say that the 14th Amendment has nothing to do with abortion at all. And so that this entire enterprise, is basically Penumbras. Was that a hand?
No.
Yeah.
And I think the comment that she was making, though, I guess the way that I read it was, so then that counter argues the original theory of the Constitution, because if they weren't, if it was completely unknown to the drafters, then how can the 14th Amendment or how can they restrict something based upon, laws that were drafted and things were completely unknown? And they use that to justify.
See, abortion was known. So who knows what quickening is? Anyone? Quickening is the point at which the fetus starts moving around, however you want to define that. And there were states that had laws that banned basically abortion after the quickening began. So there was even the notion of protecting fetal life at the point of quickening, whatever that happened to be. Right? So it was known at the time that you could terminate a pregnancy beforehand. I think what Justice Rehnquist would say is the fact that abortion was known doesn't mean that there's a right to it. And the word liberty in the 14th Amendment can't be understood as a free-floating license, that it has to have some sort of historical grounding. But he does not think that this right is protected at all.
So for him, what does liberty cover?
I don't think Justice Rehnquist accepts substantive due process at all. And I think it would basically be a prohibition on physical control, right? Physically restraining someone's liberty. And perhaps he would say you review it for minimum rationality, the optical. And he even says if they banned abortion without an exception for mother's life, that would probably be unconstitutional, but that's about it.
Well, and I guess it's just the frustration with how the courts have been interpreted the 14th Amendment, and why there is, they're picking apart how these holdings or opinions are written, because they obliterated the protections in other places. So I guess that's the frustration with how they apply the law.
Yeah.
And it also goes further to say that even now, the laws are very, they're antiquated, but the protection is just very thin, because we're just one decision away from, the things being changed totally. So I guess that's, when you go back to the Constitution, just the preamble saying that, the government derives its powers from the consent of the government. It's like, how can we give you these powers and entrust you to interpret the Constitution when it's just all over the place? Like, there's the logic in it is just, I don't know, it's hard to digest.
Thank you. I have like 3 minutes left. Mia, and then I'm going to wrap up, but I do want to wrap up. So, Mia, go ahead.
I was actually thinking about that when I was reading these cases. I was just wondering, so I thought that we didn't the citizenry didn't imbue the government with all of its power, either the federal or the state government, that we retained certain rights that on which they had no power over. And I thought that was what the articulation in the Ninth Amendment, the intent of it was. Is that wrong? Is it like the states and the federal government have all the power,
But
and
what
we are just empowered with the vote?
what are those rights?
Well, the right to be left alone, I thought was a good.
Where do you get that from?
Was that Brandeis?
Well, Brandeis read about that, but where did he get it from?
Just, I don't know, inherent philosophy.
Yeah, and that's the problem, right? You have the right to this and the right to that. What does Justice Black say? I like privacy as much as the next guy, but how do I know this is protected by the Constitution? Right? The inherent tension of substantive due process is, how do you know? And if it's debatable, if it's a 5-4 decision, how can the court exercise that right? Maybe the legislature. I mean, there are lots of states that have very broad protections for abortion. California has public funding for them. And Texas is much the opposite, right? So there are places where the democratic process leads to protection of rights like this, and there are other places where it doesn't. But then the question is, what are the constitutional rights? Right? You can have a state constitutional amendment guaranteeing a right to abortion. Several states have that. And if Roe is overturned tomorrow, in a number of states, abortion will look exactly the same. There'd be no difference whatsoever. Some states it would make a difference. All right. Any other questions on Rehnquist? Okay, I want to transition now to our next case, which we're going to be studying in class on Wednesday. So, again, Roe led to a significant backlash. Again, the abortion decision wasn't nearly as contentious as it is today, back then in the 70s, but it became it. And over the 70s and 80s, a huge component of the conservative movement became, we need to overturn Roe. We need to get away from this. It's been 40 years now, right? We need to move away from this case. And you had President Reagan nominate 3 judges to the court. You had O'Connor, Scalia, and Kennedy. And then you had President George H.W. Bush nominate 2 more judges, Justice Souter and Justice Thomas. By the time you get to 1991 with Casey, you had 8 justices appointed by Republican presidents, 8 out of the 9. And the one Democrat was Justice White, who dissented in Roe. So you had 8 Republican justices and Justice White. And in the 80s, there were several justices who suggested that we should not be applying this strict scrutiny to abortion laws, that we should be applying a more deferential standard. When you get to Casey, at first blush, there was a 5-vote block to just overrule Roe and apply a form of rational basis review to abortion laws. But that was not meant to be. And that's your reading for Wednesday. Any other questions? All right, have a good night. I'll see you all on Wednesday. Thank you. Wednesday at 6 will be, unless someone objects, will be Wednesday at 6. I'll email you for sure with the room, but probably Wednesday at 6.